Dennis O'Rourke.
I guess I was
Thank you, Mr Chairman. As I've said in previous speeches, New Zealand First does support all of the various parts of this bill for the reasons that I then gave. We do want to see a comprehensive and practical way of dealing with people who are returned, especially from Australia in the current circumstances, and who perhaps need, in fact definitely need, supervision or monitoring. But there are some parts of the bill which, if this had been a select committee process rather than what we've got here tonight, a much more restricted process, there are things that I would be seeking to improve or change. And one of those would be section 7A. And I think Materia Ture has already pointed out the fact that this is a very, very wide provision indeed, because it does refer to a person who's been convicted in an overseas jurisdiction at any time, and for an offence that, if it was in New Zealand, would be an imprisonable offence. Now, some quite minor things would fit that description of imprisonable offence. So we could be talking about very minor things indeed for the purposes of this section. And then it goes on to refer to being liable for deportation or removal as a result of that conviction. How would we know what a person is liable for in Australia or in Iran or Timbuktu or wherever? We wouldn't. So this section, I think, is problematic. It may well lead to difficulties in the future, and if this was a select committee process, I would be asking for it to be tightened up and improved for those reasons. So that's something perhaps that we will have to tend to when eventually this bill is reviewed. And when I turn over the page, I see in section 10.2 that a constable may retain an offender only for a period that is no longer than is reasonably necessary. Well, what is reasonably necessary for the purpose of getting somebody's particulars? How long is that? Is that 80 years, 8 minutes, or what? Now, I guess you could take a practical approach and simply say that what it really means is that the police can hold somebody for as long as they like until they get the information they want. In actual fact, what this section should be doing is specifying a specific period of time for which the police can hold a person, and no more, because it's too open as it is there. And then when I look a little bit further in section 11A and B, I see again that we have this reasonable test, and the police are to do what is reasonable. I don't think they're well equipped to do that. So what does it really mean when it says that a police officer can take identifying particulars, but must do so in a manner that is reasonable in the circumstances? What's reasonable? Is holding a person's head underwater for 3 minutes reasonable until they give up the information? I don't know. Neither do the police, I don't think either. So could we not be a little bit more specific and a little bit more professional in the way that these things are drafted? I'm not so concerned about the use of the term reasonable force, because that's actually defined in other cases and probably in other legislation. The point I'm making is that if this was a select committee process, we'd be getting stuck into some of these terms and some of those provisions, because they're really, I think, pretty sloppy. It's not enough for New Zealand First to vote against the bill, but I would certainly prefer to see some of those things attended to. Moving over to section 26, concerning returning prisoners to complying with special conditions imposed by the court, I think that's all fine except for one, which is subsection 3C, where a court may not impose a special condition unless it is designed to provide for the reasonable concerns of victims of the returning prisoner. What on earth does that mean? What's a reasonable concern of a victim? That I can't understand how a court will deal with that, and it's another part of the bill which really should be improved. And again, just over the page actually in section 27, Mr. Chairman, in section 27, where I see that in terms of interim special conditions, and those are the ones I would have thought that you need to be particularly careful of because they can be imposed immediately. And it says in subsection 3 that this can happen even if the court doesn't have the information, the complete information available to it, or it is still being sought. I don't understand why that is there, because one would have thought that a court must be trusted only to make decisions when it has got enough information to make that decision on. And they shouldn't be empowered to make decisions where they haven't got information. That just doesn't make sense. So that needs attention, and that's going to cause problems. And again, in subsection 5, the application may be made without notice, and a court must not require that notice be given. There's a bit of a problem with that. It should perhaps refer to the possibility that notice may not be possible, in which case that would be reasonable, but not just a bland declaration that this can be done without notice. There should be some limiting words on that. And in the following subsection 6, I'm glad to see that at least the section expires after 30 working days, because that's actually a hell of a long time. It's a month. And probably it's too long. I would have liked to have discussed that in a select committee. Won't get the opportunity to do so. And I could go on, really, Mr. Chairman, in scrutinising the bill in this way. The point I'm making is it's a real shame that it's not going to a select committee, because we would all have had the opportunity to make some really constructive improvements to this bill to avoid some of the problems which I think we're going to get and which we'll now have to wait 2 years for a review for. So I'd like to express to the Minister my disappointment that we haven't had a select committee process, because I think that little bit more extra time would really have resulted in better legislation. I'll leave it at that.
The Honourable David Parker.
Thank you, Mr. Chairman.